Well, hello, everyone. It's so great to be here with you today. It's December 8th of 2022, and welcome to the Will Work for Food, the New Possibilities Hour. As you know, we present these programs each week where our amazing colleagues donate an hour of their time to present on some topic of interest, and then everybody of our amazing colleagues, you and those who present, have been so kind over the last couple of years to donate to food banks around the world. That's all that's asked. There is no charge. We just ask that you donate to a food bank of your choice or of the speaker's suggestion. And so one of the best times of these programs, Natalie, is of those donations, how much have we been told about?
Hi, Jean. Thanks very much. We got in just now a couple of large last-minute donations, but Jean, we are now standing at $339,439.35. The resolution industry has been incredibly generous. Thank you all so much for supporting this initiative. I'm really hoping that we can hit the 350,000 mark by the end of the year.
That would be fantastic. So please, the only way we know a number to add to this running total is if you tell us. And so you can tell Natalie, Jeff Gachavin, myself, and we will be happy to add it to the total. And we thank you so much for your generosity and look forward to much more. So thank you. Okay, so today, moving along, we have two amazing speakers. This is really a presentation that's sponsored by the ADR committee of the American College of Coverage Counsel. And so we have two of the fellows from the college here with us today. And, they're our peers, you may know them. And what they're going to be talking about is how to mediate construction defect claims that involve insurance coverage issues. And I would just ask the rhetorical question, what construction defect claims do not involve insurance coverage issue? Probably none of them. They all do. So that said, we'll get into that in a minute, but let me first introduce our speakers. Cliff Shapiro is a Chicago-based national arbitrator and mediator who has more than 36 years of experience resolving construction disputes and related insurance claims, including 23 years as the leader of construction law practice groups at nationally prominent law firms. He has handled and resolved virtually every kind of claim or dispute that can arise out of a construction project. He also has in-depth knowledge of insurance coverage issues, which often further enables him to help resolve claims. Cliff serves on the American Arbitration Association's national roster of neutrals for construction, insurance, and commercial disputes, and he has served as an arbitrator and mediator in numerous matters. Cliff regularly conducts mediation and arbitrations, both in person and virtually via Zoom and other video meeting platforms. And so we're thrilled to have Cliff here, and his food bank that he has suggested is a Greater Chicago Food Depository. And Natalie will be putting that in the chat. Now, our second speaker here, hold on a second. Well, I pull up her information, Rena Carmel. We've known each other for many years, actually. She is a senior counsel at Anderson, McFarland & Connors, LLP in Los Angeles. Her practice focuses on analyzing complex claims under commercial general liability policies and other types of policies, as well as coverage litigation. She's advised clients on coverage issues in numerous construction defect actions. She's admitted to practice before all state and federal courts in California, as well as the Ninth Circuit Court of Appeal for the federal courts. Rena is a foster home volunteer with Guardian Angels for Soldiers' Pets, a civilian organization that finds foster homes for pets of military on deployment or military and veterans with an emergency hardship. And her suggested food bank is one that we know here that we've had before and is welcome, the Jewish Family Services Los Angeles. So that link is also in the will be, if it's not there yet, in the chat. And I just do need to add a caveat that disclaimer, if you will, this is an academic discussion. The views and opinions expressed in this session do not necessarily reflect the opinions of all of its speakers or everything expressed herein, nor of their firms or clients. So that said, welcome. We are thrilled to have you here, Rena and Cliff. I would say that the floor is yours. If you can tell us a little bit about your food bank and why you chose it, and then we'll get on to construction defect.
Well, good morning, everybody. Well, good morning from Chicago, at least. Look, this just really hits the sweet spot for me. This whole idea is just marvelous. I was on the board of directors of the Chicago Food Depository years ago, and have always been, a big fan of the Chicago Food Depository and food depositories around the country. And I guess I'll start by just, saying that I'm a little bit of an odd duck. I'm a construction lawyer. Okay, I headed up construction law practice groups for many years before I became strictly working as a neutral. And the thing is, I wasn't smart enough in the early days to do what a lot of construction lawyers did, which was to kind of run away from the insurance issues, and you'd run over to your partner's office who knew something about insurance. And I wasn't smart enough to do that, and I dug in on the insurance issues myself. And so here I am speaking to you about construction claims, but primarily about insurance issues today. And they really are incredibly important to resolving insurance claims. The insurance claims that usually arise out of construction cases. And construction cases are hard. They're hard to mediate, and they're hard to try as well. And the primary reason they're so difficult is that they often involve complex issues as to causation. I used to say to my colleagues, it all comes down to causation. Why did this happen? There's always a problem. It's usually a physical problem, but why it happened is often complex. I was at a mediation recently. It involved 14 parties. That was a record for me. But of the 14 parties, there were 5 or 6 of the different parties, each saying that somebody else had caused the problem. And on smaller scales, that is pretty typical of the thing that you're going to run into in a construction case. But then the other layer that makes it so complicated is the insurance side. Because what usually happens is you have a lot of parties, each one of which may have insurance, and they may have various kinds of insurance. They may be insured under different policy periods. They may be insured on each other's policies to the extent that they're additional insurance. And so that additional layer of complexity is what can really make construction claims challenging. But I'm here to tell you, they can be resolved. Rena?
Thanks, Cliff. I come at this from a different perspective from Cliff. Cliff is based in Illinois. I'm based in California. Obviously, the state's laws are very different. I have represented insurers my whole career, and I look at the claims that are sent to me. I defend the actions that are sent to me, and oftentimes these are construction defect actions. Building is a huge industry in California in particular, and in neighboring states as well. And I will agree with Cliff that the issues in construction defect litigation are tremendously complex, and the insurance issues are tremendously complex. I like a good, complex, thorny challenge from an intellectual perspective, but that is also not necessarily great news for my clients, the insurers, because that translates oftentimes into difficult issues to resolve. The issues in particular of what the policy coverages provide, whether any exclusions are triggered, looking at policy period issues, looking at additional insurance issues. I have attended numerous construction defect mediations. Cliff gets to see them for the whole day or the whole 2 days or the whole week, and however long they go on. I am usually just there as whatever piece of that puzzle I have, and dealing with my own unique issues. And it really is fascinating to watch a good arbitrator or a good settlement judge work with all the various parties to try and achieve global settlement if that's possible. I've chosen to support SOVA which is part of Jewish Family Services of Los Angeles, because my family has supported that food bank ever since I was a little kid. After college, I volunteered at SOVA once a week, and I've continued to support it ever since. I'm just sorry that the need is there to support these kinds of charities, but grateful to have the opportunity to do it.
Well, that's so wonderful. Thank you both. Well, let's get to it, right? So first question for you then, what kinds of cases are we talking about? And can you give examples of cases?
Well, so earlier in my career, the typical case I was running into was the cases where you had developers in Chicago and around the country that were redeveloping older buildings, warehouses, and turning them into condominiums or apartments. And it would be often the case that the resulting construction had defects of some sort. And a lot of the cases seem to involve water intrusion. And so you'd have a situation where the exterior contractor's work was allegedly defective. You have water coming into the building that may be damaging other parts of the building or damaging the property of the unit owners. And those cases were somewhat typical. And the way the CGL policy works, the commercial general liability policy, the way it works is it covers property damage caused by an accidental occurrence unless excluded by one of the policy exclusions. And so these kinds of cases have property damage. You have water intrusion damaging things that is caused by defective work. And we're going to talk a little bit more about whether that defective work can be an accidental occurrence, which is a big issue across the country. But those cases were pretty typical, and I fought a lot of those cases. But what's happened is, just as Jean pointed out, just about any construction case involves in some way property damage where you have defects. So I had a rash of recent cases where you had sprinkler systems, where the sprinkler system, the emergency fire sprinkler system, broke and caused water damage when they broke. And then other cases I'm now dealing with are really large chemical plants around the country. And these chemical plants, are industrial, but you have defect claims arising out of those kinds of large projects, including things like defective welding. Well, is defective welding, is that kind of defect the kind of defect that can trigger coverage under any of the insurance policies? And so all of those kinds of construction projects can result in not only the construction claim, but related coverage mitigation.
Rena, what kinds of cases are you seeing then?
I will agree with Cliff that cases that involve water intrusion are probably the most frequent and some of the most difficult to analyze. And certainly those are ones that cause some very complicated kinds of alleged damages. The issues as I see them tend to focus on who is going to be held liable because of property damage caused by an occurrence, which is the insuring agreement under the current CGL main form. And so looking at those issues, trying to understand what the damages are and how they came to be and who might be liable for them tends to become very complex. Another issue that we frequently have in California will be grading issues. California obviously is hilly. We have a lot of earthquake faults. Where the project came to be situated in the first place is often an issue as to whether it might be situated on a fault and who might have known about the fault in advance or not. And then how the project was graded. And those issues tie in oftentimes. So those are probably the main sources. There's also a lot of faulty workmanship kinds of claims that I see, and parsing those issues out is often quite challenging. And from the insurer's side, we don't necessarily get all of the information we might need and that we repeatedly ask for in order to be able to analyze those issues. So that makes it even more challenging.
When you talk grading, are you really talking then the resulting subsidence claims?
Oftentimes that will turn into a subsidence claim, yes.
Well, then, what kind of coverages are we talking about as opposed to the claims? So what kind of insurance coverages, policies are we talking about, and does it matter?
You know, I think it matters a lot, and we can talk some about that. But the kinds of coverages we're talking about are primarily CGL coverage, which again is the commercial general liability coverage. And that's, you know, if you're a policyholder who holds a policy like that and you are sued, you have coverage for, if you're found liable for property damage caused by an accidental occurrence, unless it's excluded under other terms in the policy. But another key part of that is it could trigger a duty to defend. And so the policyholder could trigger having the insurance company help pay or pay entirely for their defense, which is a very big part of that kind of coverage. The other big policy that I see typically is professional liability coverage. Professional liability coverage is for the design team, the architects and the engineers. And again, that policy will apply for professional malpractice claims, and it will also provide a defense to the parties that are facing the claims. Another big area in the construction world is what we call wrap insurance policies. And those kinds of policies are either bought by one of the main contractors or by the owner of the project. And it can actually cover, it will cover any party to the construction project who is what they call enrolled in the insurance program. And those can raise different kinds of issues. Usually those are, again, either structured as a commercial general liability type coverage or professional liability type coverage. But those are the primary kinds of coverage that I see.
And if I might, Cliff, when you say wrap policies, are you talking about OSIP and CSIP, the owner-controlled insurance programs, or contractor-controlled insurance programs?
Yeah, exactly. That's exactly what I'm talking about.
Okay, great. All right. We can get into that then down the road. Rena, what about you with the kinds of coverages that you'd be talking about, and how then does it matter?
I see the same types of policies that Cliff just referred to. More rarely, I will also get asked to look into issues under perhaps an excess type of policy, although that is more rare. Usually how the issues come into me is that one of the subcontractors on the project, such as the landscaper or the painter or the drywall folks or anyone involved with plumbing, will have had a smaller CGL policy. Usually these are independent vendors, not part of major national corporations. And they have been sued because everyone gets a cross complaint. Once the developer or the project owner are sued in a CD action, they turn around and they tender and cross complain against every single vendor who they can locate. Another issue, interestingly, with what insurance policies might be implicated for analysis is that oftentimes record keeping is not the greatest as to insurance policies. So I tend to find that vendors may not know who had their policies, or if my client issued a policy for 1 year, but the vendor had a policy with a different insurance company the next year, sometimes the vendor can't find that policy. And that goes to whether contribution rights and obligations may exist for companies if there's a potential for coverage. So that's another insurance policy issue that I tend to deal with. And that becomes especially significant in mediation, because if more than one insurer may be involved, it makes sense to try to bring as many people to the table as possible. But that itself is not always possible.
Right, and those lost policy cases, those are very complex in and of themselves, proving up, whether the coverage was there or not. But when you talk about multiple insurers, and you talk about the plumber, for example, or one of these subcontractors, they oftentimes would have named the general contractor or the developer, whoever, as an additional insured under their policy, right? And so you've got what you were talking about in my mind as I was listening to you, I'm thinking you've got the subs policy, you've got the GC or the developer's policy and consideration, and then you've got them pointing fingers at each other as to additional insured status or not, right?
Right. So oftentimes sorry, Cliff.
No, go ahead.
Oftentimes the subcontracts with the vendors will call for the vendor to add the project owner and the general contractor as an additional insured under the policy, but that doesn't necessarily make the project owner or the general contractor an additional insured, because that depends on the terms of the policy itself. So what the parties' contract says is important in the analysis, but that in and of itself does not confer additional insured status.
Yeah, and so what happens is, you can have parties that have potentially coverage under a bunch of different policies. And, stepping back just for a second, the reason, from the mediator's perspective, the reason these cases can be resolved is because everything we're talking about creates risk. Okay, and my view as a mediator is it's all about analyzing the risk and monetizing it. And so, when we say that this is a complex issue, it's another way of saying that it's uncertain. Okay, and so we by the time this case gets to a mediation, you're going to have issues where Rena is going to be there as counsel for the carrier, but she's likely going to be telling her carrier that there's some risk that they do have coverage, even if they think that they have a good case, that there is no coverage. And that's risk. And then the job of the mediator and the parties is to then think about that risk and what it means in terms of outcomes if they had to go to trial. And then we have to try and come up with dollars and put dollars on it to resolve the case. And so the good news in the construction case, from my perspective, is these are always complex, they're always difficult, but it creates risk. And if it creates risk, and there really are two sides to how this could come out, then that seems to militate towards finding a way to resolve it short of trial.
Yeah, absolutely. So then why does the coverage matter? Although we kind of touched on it, I think you had some other things you wanted to say on it. And how does it impact the potential resolution of the construction claims at mediation?
Well, I'll go first, Rena. It's just, I think there's one big issue that we need to talk about a little bit on the substance, and that is under the commercial general liability policy. Again, you have to have property damage caused by an accidental occurrence. And what's happened during my career is that issue has become a hotbed issue with divergent decisions across the United States. And the question that has come up and that is divided across the country is whether defective workmanship is an accidental occurrence under the CGL policy. And believe it or not, you have the exact same policy language, you have the exact same contract, and it has been interpreted completely differently in different jurisdictions across the country. And I've been speaking and writing about this for years. I early on in my career, I saw this, and it got to the point where it did seem to me that there was a correct and an incorrect answer to this question, given the history of the CGL policy and how it evolved over time. But not everybody's listening to Shapiro about that. But my articles have been published in some state Supreme Court decisions. And that's kind of not really the point, because as a mediator, I look at the risk. And so, but what I guess I'm trying to say is it really comes down to the jurisdiction in many areas, whether you're going to potentially have coverage or not. And it ties heavily to the risk that you're going to have with these kinds of claims. I hasten to add that I have a 50-state survey on the occurrence issue, the threshold occurrence issue. And if anybody would like to see that, please just contact me and I'll send it to you.
So I do think Cliff is correct when he says that state law varies a lot culturally, California is a very pro-developer state. And so that informs at least some of, well, it informs all of the laws and statutes we have on the books, but it also can inform a lot of the court decisions interpreting policies in this context. The reason that coverage is important is that while faulty workmanship might be an occurrence, it can depend on the facts. There are many cases out there, appellate cases, discussing that the general contractor or one of the subs knew that the floor was laid defectively and they proceeded anyways. And there's no reason that something like that should be deemed an occurrence. That is oftentimes a challenge for coverage counsel to go about figuring out, especially in terms of getting documents, getting actual allegations out there, and if need be, getting reports from consultants who can opine as to whether that's the case or not. And then there's the issue of looking at policy exclusions and seeing if what happened would be within an exclusion. So it really does depend on the case. As Cliff said, sometimes a coverage lawyer might be telling his or her client, yes, there might be some coverage risk here. Sometimes the coverage lawyer might be telling her or his or their client, there's more of a risk here of spending defense costs, while at this mediation, we have the opportunity to settle for a smaller amount, and that might be a cost benefit. Plus it gets the insureds out of litigation. But one of the issues in California that complicates things, and I'm going to go off in a little bit of a different direction here, unlike most states, California's duty to settle law is not on a first come, first served basis. So in California, an insurer does need to settle globally and get a release in favor of all insureds. Unless there's something unusual or all of the insureds agree, the insurer should not settle on behalf of just one of the insureds and leave other insureds exposed to risk with lower policy limits. And so that's a reason that insurers might find themselves in a construction defect action and having trouble settling, even if they might want to, because of the need to get everyone released. And especially recently, plaintiffs' attorneys are holding out and really trying to exhaust all possible sources of recovery that they can before letting anyone out. And that's been a marked upward trend, especially since the pandemic began. So settling out has become even harder than it probably used to be.
Yeah. Well, another point that I think should be stated is it's hard to overstate the importance of the duty to defend. Because the CGL policy and professional liability policy provide not just coverage if you're found liable, but they provide this defense. And as a matter of law, I think in every jurisdiction, the duty to defend is broader than the duty to indemnify. And what that means is that if there's any chance of coverage under the policy for the claims made against you, then you're entitled to a defense. Okay, and the insurance carrier has to provide you with that defense. And under the law in some states, including Illinois, the carrier is obligated to provide you with a complete defense, even for claims that might not be covered by the policy. So that's incredibly important, not just in terms of the benefit it can provide to a policyholder, but it becomes important in the mediation context because it brings everybody to the table. So now I'm at the mediation, I have the party there, the insurance carrier is there because they're involved, because they're providing a defense. And the defense of these cases is not inexpensive in and of itself. So there are cases within certain dollar ranges, I'm finding, if you have cases that are not the huge cases, but it's a $5 or $10 million case, and you have several parties, each of whom has a carrier defending them, and you're looking at years of litigation and with experts involved in all of that, oftentimes the carriers can find a way to make economic sense out of resolving the case based on the anticipated cost to defend. And so, that's another avenue towards resolution.
It
Right.
can be. It absolutely can be.
And just so we're clear here, just the language that between the two of you, I mean, I notice it because I am, I was also an insurance lawyer in practice, but it's so interesting. I don't know if it like Cliff, when you talk about any chance of coverage, I'm sure that Rena would say it's not any chances of the test, it's a potential for coverage, not merely a possibility for coverage, right?
You might say that.
Yeah, Cliff from the American College was on the policyholder side, and Rena was on the insurer, or is on the insurer side, right? In terms of your backgrounds. And that's the beauty of this, where you can see not just in the language, but some of the thought processes of how it would work then also in mediation, or just in general, in litigation. So that's go ahead.
I hasten to add that yes, I was a policyholder lawyer for many years. I hasten to add that as a mediator, I'm finding that the carriers actually like me involved because I think they like that I have credibility when I go into the policyholder's room to tell them about the risks.
Absolutely, you can talk the talk, on that, and you do know the issues. So I didn't mean to imply that you didn't, or that you were one-sided or biased, because of course you're not at all. It's just the background for the college. Yes. Okay. So let's get into mediation then. We've laid the groundwork here. First of all, does it matter where the mediation is held? And then do you have any practical tips? What's the most important thing that you think of to having a successful mediation that involves both the coverage claims and the related insurance issues, and getting the defects issues, the substantive underlying issues resolved?
Rena, you want to go first on that one?
Sure. To me, it does not matter where the mediation is. I've been to mediations in all kinds of locations. Pre-COVID, it was always nice if the mediation was in town, because then it's just quicker and easier to get to and less expensive for my client. Having mediation by Zoom is a wonderful thing. It saves everyone a lot of time. With a construction defect mediation, usually there are so many parties present and involved that you spend even more of the day doing other things, doing other work, while you wait for the mediator to come to your room or your chair in a particular corner of the lobby to talk to you. And that depends on usually who the insured subcontractor is and how important they are in the lineup. So I've been everywhere from the drywall or the plumbing contractor or the roofing contractor, and I get called on first, and I am negotiating for a good part of the day. But I've also been, the sub has been a very, very minor player and is only named for the sake of thoroughness. It might be the person who installed the staircase banisters. And in that case, I will usually sit and wait. I get a lot of other work done. Sometimes I've had kind of mid-level subcontractors in terms of what the allegations in the case are, but I do have a dispositive exclusion. And I'm there, if a defense is being provided, I'm there because it's under a pretty stringent reservation of rights, or there may be no duty to defend, but I'm there at mediation just to protect anything from going really sideways and everyone trying to pin everything on this one contractor. I once spent 2 days at a mediation and about 5 seconds with the mediator, a retired judge, and I showed him what would have been Exhibit A had we had to go to trial. It was the 1-page exclusion that completely barred any coverage as to this particular case. The judge read it, looked at me and said, okay, well, it's been very nice to meet you. I won't see you again. And that was it, and we were done. But I was there just to protect against probably other subcontractors trying to pin anything on my client. So that's really how I look at it. But Cliff, you probably see a much broader range of what goes on because you're dealing with everyone, and I only ever have a small piece of what's going on.
Well, they're very full days for me. There's no rest for the weary, that's for sure. You know, this issue about Zoom versus live mediation is fascinating to me because during COVID, we all learned that yes, Zoom actually can work and work effectively for mediations and arbitrations. I was in the middle of an arbitration when COVID hit, and we went to the Zoom platform and got it done. You know, Zoom for mediation can work. The ability with the breakout rooms, where the mediator can move people into various rooms and go in and out of the rooms electronically, it works, okay? But what's fascinating to me is that since COVID has eased up, and to my surprise, the calls I'm getting, everybody wants to be in person again. The lawyers want to be in person again. It looks like their clients want to be in person again, you know, including this 14-party one I did up in Minnesota recently. Now, I think there's another twist on it, though. I think that even when we do it in person now, it is pretty common for some parties to attend remotely, and that seems to have opened the door for some ease, particularly with the carrier representatives. It seems like the insurance companies and their representatives can appear remotely, but it's better than being told, you know, they'll be available by phone. Instead, you know, I go into the room and I've got some people in person, and we bring the insurance representative via Zoom so that we're talking, you know, and so that seems to be a pretty typical scenario for me these days. I will say that I do have a slight preference for the live mediation, and the reason for that, it's interesting. It ties to the unanticipated, unscripted interactions that happen at a live mediation. It is not uncommon for there to be a critical moment in the hallway where the lawyer steps out of the room from their clients or from the insurance representative, and we have a chat that is important to resolution. And that can be done via Zoom. You know, somebody can call me on the cell phone or something, but it just doesn't seem that it happens as much. And so it's that sort of unscripted interaction that I find is actually important at the live mediation, and it can be incredibly helpful to resolution.
I find that is true on the coverage side, but for other types of actions and not CD disputes. I find that's true, that being in person or being able to see other people is useful for cases that involve individuals. But I think from the insurer's perspective, CD cases generally tend to involve insureds that are corporations or businesses, and we don't usually tend to have the same involvement with individuals, so that the need to be in person is not really there. The need to see everyone else is not the same. And it can be done a lot more expeditiously by Zoom.
Yeah, no, and I think a lot of the carriers and the representatives, you know, do have that view, and I respect that view. You know, it's, again, as the mediator, it's interesting because it's a lot of it is about and the one thing that I have used Zoom for, and I didn't do this before COVID, but now in a complex mediation, almost always, I meet with each party and their representatives, including their insurance representatives, before the mediation by Zoom. And that, you know, that helps sort of get us going, helps start establishing that bond, hopefully that bond of trust and respect. And also it avoids having to take an hour, you know, with each party at the mediation. We've done that. We've done that in advance. We're more ready to go. So I've also found that use of Zoom to be incredibly helpful to the mediation process.
Sure, because you as the mediator are dealing with the homeowners or the HOA. In a large CD case, the insurer is typically quite separated from the homeowners. And it's not like a one-on-one dispute between two insureds, say a neighbor dispute that can also get into some building and land use types of issues. That's an entirely different kind of animal than a large CD mediation. In the case with, say, two neighbors, we would absolutely want to see everyone on Zoom and at least be allowed to view the plaintiff and see their image up on screen, see how they interact. But again, in a large CD case, that need is just not there. If it's a large homeowners association, or if the project owner is some kind of corporate entity, there's really very little to no need for us to personally interact. We will if the mediator requests it, but I have had that happen only very, very rarely.
You'd earlier mentioned, I think Cliff, it was you, RAP policies. And now how you're talking about the numbers of people and parties, and I mean, it gets astronomical in a lot of cases. But how is that different if the policy involved is one of those RAP policies when it comes to the mediation? And what could mediators and counsel in practice expect to encounter in that type of mediation?
Well, that's a good question. I'll be very curious to hear what Rena says. From my perspective, both as a practitioner and as a mediator, it can change the dynamic. What's interesting about the RAP policy is that if coverage is triggered for the claims, it's my understanding that the RAP insurer, the insurance company, is obligated for each of the enrolled parties to provide them with coverage, including a defense. And so the insurance company in these kinds of cases may be obligated to provide a different set of lawyers to a different set, to each of the policyholders that are insured under this RAP policy. And so that's a big burden on the carrier. Which can help, again, from the risk analysis, can help move us towards a resolution discussion. I have seen a few times that certain of the RAP carriers, certain of the insurance companies, when they have these kind of cases, are motivated to try to resolve early on. And there are some creative ways that they are willing to explore that does not exist in the typical case. So, for example, sometimes in that situation, they're willing to go to a mediation without requiring all the different subcontractors and lower tier parties to be there, but to try and mediate on behalf of everybody at an earlier stage. And that is unusual for a carrier to sort of step up and say, hey, we want to get together, we want to mediate, we're here to talk on behalf of all of our policyholders if we can reach a resolution on this.
I tend to not get many coverage questions under RAP policies. The reason is that those are in fact designed to encompass all of the vendors who worked on the particular project. So any coverage issues are much more limited under the RAP policy. And I find that the only issues tend to be notice types of issues, figuring out if someone is bankrupt, possibly discussing whether someone might be entitled to independent counsel. It's nicknamed CUMIS counsel in California. But I don't tend to get nearly as many coverage issues under RAP policies. CGL policies and professional liability policies, on the other hand, can involve very thorny coverage issues.
The other thing about RAP policies that's very important is that because they're, they tend to be more negotiated than other kinds of coverage, which is on standard forms usually. these negotiated policies can be very different in a good way for coverage. So for example, a wrap policy may define occurrence to include construction defects. That actually exists in some wrap policies. And some larger insurance programs on behalf of larger developers are very good for coverage. I had one where all of the business risk exclusions that would normally be a thorny issue in a construction defect case, they were removed under the program for a large developer by agreement between the developer and their insurance company. So you really do, I mean, you know, insurance lawyers will always say, read the policy, and it is important to actually read the policy.
And you wouldn't, in those situations you're talking about, my understanding, and correct me if you think I'm wrong, which is certainly always possible, but that the developers generals are not suing the subs and vice versa. They're not suing each other, which minimizes it. They're dealing with the main claim from the main claimant to settle that claim.
Well, that actually that's a good question, Gene, and it gets complicated because even if there's a wrap policy, it may be in the underlying litigation that you have the typical structure of the litigation where the owner is suing the general contractor and its design team, and the general contractor is suing downstream to its subcontractors, and they sue downstream to their subcontractors. That may still be happening. And then they're all covered under this wrap insurance policy. And then the question is, now what? Okay, now what happens? And it's difficult. It's difficult for the carrier because, again, the carrier may have to provide each of those parties a defense, but they're fighting with each other under the same insurance policy. I mean, it gets complicated and difficult.
Well, speaking of wraps, we want to make sure we have plenty of time to wrap this up with practical tips. So what practical advice would each of you have for those who might become involved in a mediation that involves construction claims with related insurance coverage issues?
Rena, you want to go first?
Sure. And actually, before I start, I got a direct message in the chat asking for what California law talks about not being able to settle on behalf of just one insured. Kind of surprisingly for California, it's not a statute or any insurance regs, but it's case law. So I'll just give a couple of quick cites. Lehto, L-E-H-T-O versus Allstate, 3-1 Cal App 4th, 6-0, and that's a 1995 case. Also take a look at Strauss versus Farmers, 2-6 Cal App 4th, 1017, 1021. That's a 1993 case. And then actually in the context of an auto case, but also a more recent case, Graciano versus Mercury, 231 Cal App 4th, 414, and then several pin sites, 425, 426, and 428, and that's a 2014 case. And that's actually the main practical tip I have, or relating to it, because on the insurer's side, it's really important to know who's going to mediation, what the demands are, and who they are made against, especially if it's a policy in which anyone bigger than the small sub may also be an additional insured, because the insurer has to know what the settlement opportunity may be to determine whether in fact it can settle and achieve a settlement on behalf of all possible insureds. But before that, the insurer needs a lot of advance notice about the CD action. The issues that Cliff mentioned about investigating the claim are significant and often take a lot of time to parse out. So the insurer needs to be involved and given reports as they are generated and provided with all of the information about the claim and what allegations are made in the lawsuit and who did what in order to be able to analyze this. The insured needs to comply with its obligation to cooperate under the policy and supply the insurer with all that information on a timely basis. Because evaluating whether any settlement demand reflects the insured's potential liability, whether the insured could be held liable, what the damages exposure is. The insurer needs to look at all of that information in order to determine whether the settlement demand is reasonable and whether there's any possibility of an excess verdict against the insured, in order to be able to analyze whether settlement may be productive, and if so, what an appropriate amount may be. Oftentimes, particularly smaller subs may be more familiar with insurance claims that involve a fender bender. And those are obviously usually pretty quickly resolved. And they don't appreciate that CD action is exponentially more complex. And that's true even if the CD action involves just construction defects to one house as it was being remodeled. So information needs to be provided early and be provided often. As soon as mediation starts being discussed, the insurer needs to be advised about that. And the insurer needs to be kept apprised of what the demands are, what any negotiations are, and know what kinds of arguments it's going to be facing so that it can evaluate settlement. And so that is really my main takeaway, is communicate with the insurer, please, early and often.
Yeah.
Good advice. Cliff?
Well, for Natalie, I'm going to go, where do I start with? She's in France. I guess if I was thinking of tips, I would have two. One is, I think it's very important to understand that under the commercial general liability policy, the notice obligations can be a tricky trap, okay? Because under the CGL policy, the policyholder is obligated to give notice of the accidental occurrence, and then separately obligated to give notice of a lawsuit if and when it happens. And it's that first one that can really trip up people in the construction world. Because what happens is, you've got the condo association and there's some water leakage, and in the first year it's treated as a warranty claim. And nobody thinks of their insurance. They go in and they do some repair work and they fix it. And a year later or 2 years later, it's discovered that there's a systemic problem and it's a big issue. And a lawsuit is filed. They give notice of the lawsuit, but they didn't give notice of the occurrence when it first came up. And the insurance company might say that you don't have coverage because of late notice. So I think that's something that policyholders need to be very careful of. But I agree with Rena, in terms of the mediation context, it is extremely important to figure out early on whether or not you need to be communicating with your carrier early on, but particularly where the carrier is providing a defense under what's called a reservation of rights letter. So the carrier is defending but reserving their right to deny coverage. If you're going to go to the mediation, and if coverage issues are going to be an issue at the mediation because the carrier is going to be at the mediation saying, we may have a duty to defend, but we don't have a duty to pay for any judgment against this person if we go to trial. If that needs to be mediated, the policyholder needs to figure out early on, do they need a coverage lawyer at the mediation on their behalf, separate from their insurance provided defense lawyer? That's a big issue. And you can get to the mediation and the policyholder might be at the mediation and not have realized that somebody has to be arguing on their behalf at the mediation with Rena about coverage. Okay, and so that I think it's incredibly important to the mediation process. And then to Rena's point, this needs to happen way before we get to the mediation. The goal is to be at mediation, ready to resolve. People need to be there with full settlement authority. If you want Rena to be at the mediation with settlement authority, she has to have the information for her file in time to analyze it, discuss it with her client, and obtain that settlement authority from the insurance company. That takes time. So preparation for the mediation is absolutely critical if we're going to get it resolved.
And you mentioned all the folks involved. I mean, as a mediator, and when I was in practice, just what you talked about, Cliff, so often you've got a little coverage mediation going on between the insurers and the insureds. You've got the mediation going on between the insured and whoever is suing it, and the whole picture. So there's so many dynamics. It's so important for that early intervention. So that's great. I do have some questions for you that were in the chat that I think that we'll go to, if that's okay. This one, let's see. First of all, people are thanking you, Cliff, for your article, and would like it. Yes, so thank you for putting your email address in there. Let's see. Okay, so we have, let's see, who was this? This was, let me move this question up. Okay. Joanne, do you want to put up your hand and just ask your questions? Otherwise, I will. You want to unmute yourself? Okay. Well, if you do, then to speak up, but otherwise, just to keep things going. These are questions for you, Cliff. Do you have suggestions on how to effectively deal with the recalcitrant carrier? Then also there are issues asking about waiver of subrogation issues in mediation and the importance of the pre-mediation call with the carrier.
Well, okay, all good questions. I mean, look, I think the best way to deal with the insurance carriers is to be prepared. And so again, I think if there are coverage issues, I think it's very important that the carrier be told the policyholder's perspective on that, and that the carrier be given their opportunity to respond. Because in the role as mediator, I need to be looking at both of those and then be talking with each side again about the risk. And if there's risk, then both sides are going to need to compromise. And it's interesting because these do run parallel to the construction claims. The construction claims are usually coming down to causation and the risk involved of being found liable for causing the problem. I saw a question in the chat about decision tree analysis. And yeah, if somebody is sophisticated enough to use decision tree analysis, because it can be complex in a construction case, but it is a tool that can be used to help look at the risk, and it forces you to put percentages on decision points and come out with a probability of success or failure at trial. Well, I love that, because as the mediator, that's what I want people to be thinking about. Because if you're putting a probability of success on or failure at trial, we can monetize it. We look at the claim, we look at the percentage probability, and it's a tool to use to help rationally analyze the risk. And so I love decision tree analysis. Waiver of subrogation, I suggest that we defer that discussion because I don't think we have time for it. And we can move on to some other questions.
I'll just jump in and say that I don't know what it means to say that an insurer has been recalcitrant, but to the extent anyone is talking about that coverage defenses for the claim exist, it does make sense to get everyone at least talking beforehand about what the coverage defenses are and how that may impact what happens going into mediation. Because Jean and Cliff, as mediators, their time is really valuable. They're dealing with a ton of parties beyond just me. And I can only imagine that it must be frustrating for the two of you to come into my room, for example, and hear, oh, we haven't gotten the information we need, or we've asserted this exclusion. It seems to bar coverage. We think we can sustain our burden of showing that it does bar coverage, and we haven't heard anything different from the policyholder. And that's going to impact, how much money, if any, we might be able to put towards settlement. And the more those issues are worked out beforehand, I think the smoother the process goes for everyone.
you talk about working them out beforehand. That makes so much sense. What do you each feel about having bifurcated or phased mediation sessions to deal with these various issues?
It can make sense. It can make sense. I mean, it's interesting. Usually at my mediations, you know, it's the construction party that is there with their defense counsel, oftentimes hired by the insurance company, and possibly also there with their coverage counsel. And you know, and we can be doing that at the same time, but it does happen where sometimes we learn that what's important is to essentially mediate the coverage issues. And it is not uncommon for us then in the next phase to go at that separately if we have to.
The one advantage to a CD mediation over any other kind of mediation for the most part is that the mediator does understand that coverage issues are going to be paramount. Sometimes in other types of actions, I find myself having to convince a mediator that coverage issues are important.
Fantastic. Okay, well, it's the top of the hour. And so if anybody has any other questions, feel free to contact Rena or Cliff directly. And thank you so much to both of you. This has been fascinating and informative. And thank you so much to everybody who's been here. Please, it's a holiday season. Give often and let us know what it is that you're donating to food banks. And thank you so much, all of you. Take
Thank
care.
you all.
We'll see you next week, same time.
Thank
Bye.
you, Jean. Thank you, Cliff. Thank you, Natalie.
Thank you.
Thank you.